Good morning, Mr. Chairman, and thank you for holding this hearing. Look, major federal decisions should be informed by an understanding of how they impact our environment. That's the simple idea behind NEPA. NEPA requires the federal government to take a hard look at the environmental impacts of federal actions and projects. There has to be a causal relationship between a project and the alleged impacts. But CEQ's revised draft guidance on greenhouse gas emissions turns this upside down. The new guidance assumes that any greenhouse gas emissions contribute to global climate change, and so they are environmental impacts. Now, indulge me this indelicate statement, Mr. Chairman. I emit greenhouse gases. You emit greenhouse gases. The ranking member, our panelists, we all emit greenhouse gases. You can measure our emissions with a high degree of accuracy. What's difficult but not, in fact, what's difficult but perhaps impossible to measure is how much our emissions actually contribute to global warming, or global cooling, or other global climate changes that impact our environment. As our experts will reveal today, this connection is difficult enough to make even if you analyze the greenhouse gas emissions of the entire United States. Yet CEQ is now telling agencies that if a project emits greenhouse gases, it is a de facto environmental impact. That will lead to project delays, project modifications, added costs, mitigation costs, and in some cases even project denials. From public lands permits to energy production to roads, pipelines, there isn't a corner of the United States that isn't touched by this new guidance, and the cost could be enormous. This so-called guidance didn't even go through rulemaking, which is astounding when you consider its economic impacts. I look forward to the hearing. I look forward to listening to our panelists today. Some will question the science and legal basis for this draft guidance. You know, I have with me here somewhere a copy of NEPA. I brought it with me. 6 pages. Well, it barely goes over to this 7th page. 6 pages, the National Environmental Policy Act. It's supposed to inform federal decisions, not dictate them. But after 45 years of agencies and courts reading more and more requirements into NEPA, this 6-page bill has generated reams of paperwork that created lots of greenhouse gases. So many greenhouse gases that it could fill the halls of Congress and then some. Some of this paperwork has likely produced environmental benefits, but much of it is duplicative and unnecessary. And CEQ's draft guidance is a prime example. This guidance will create far more paperwork and greenhouse gases than environmental benefits, regardless of one's position on global warming. We need to recognize, Mr. Chairman, that NEPA procedure has become so time-consuming, so costly, and so fraught with litigation that in many cases the process alone dictates outcomes. Only then can we have a reasonable conversation about how the 45-year-old NEPA could better serve our environmental needs in the 21st century. Thank you, Mr. Chairman. I yield back. Thank you, Mr. Chairman. My first question is for Ms. Goldfuss. Welcome for being to the committee. CEQ says that this draft greenhouse gas guidance is not a rule or regulation. This document does not establish legally binding requirements in and of itself. What does that mean?
Well, Congress has given CEQ the responsibility to interpret and implement NEPA, and that means working with the agencies to give them the guidance they need to do it properly. So we have issued guidance on several occasions on many issues to help them with that process. So this guidance falls in that category.
Yeah, what does it mean, though, when it says this is not legally binding in and of itself?
It means it's not a regulation. This is guidance for the agencies to help them with their decision-making process.
So you expect agencies to follow the guidance?
We do. It is our hope. That's part of the purpose of putting out the guidance.
Okay, so what if an agency says, we don't want to follow the guidance?
Well, agencies do have much discretion, and on a case-by-case basis, they may make that decision, but it is CEQ's hope that they will use the guidance when appropriate.
Okay, so if a disagreement occurs between agencies about the application of the guidance, would CEQ get involved? Would you mitigate or arbitrate that?
That is not necessarily our role. On occasion, a project will become so contentious between agencies that we will get a referral, is what it's called, and then we will help them work that through. But it is not our intent to intervene on that level.
So how does a
discretion.
referral happen? Does one agency sort of tell on the other agency? You know, they're not playing nice with us, they're disagreeing with us?
No.
Well, how does it work?
It's an official process. We have not had one since the 80s to CEQ, though, so it's been a long time since there's been a referral.
So what would be the practical effects of an agency not following the guidance?
If they went forward and determined that it was not appropriate to use the guidance on their project, they could continue with their process, and then if the courts determined that was not an appropriate choice, they would then have to redo.
So the courts can get involved? Even with a guidance, a non-binding guidance, access to the courts is somehow...
The guidance is not what gives them access to the courts. It's the regulations for NEPA.
Okay, but how does the guidance layer on top of that to give court access?
It doesn't give court access. The guidance is simply a tool for agencies when they ask questions about how to implement NEPA.
Okay, well, if they say, if two different agencies are interpreting the guidance differently on how to apply NEPA, are you going to arbitrate that?
No.
What's going to happen?
The agencies have discretion to implement NEPA the way that they see fit on a
project-by-project basis. Why are you providing this?
Basis.
What is this guidance for then? Why are you doing this?
We have a series of court cases and questions from the agencies specifically about how to address climate change. We've heard from the courts, as Mr. Martella also referenced, that including climate change is an appropriate consideration in NEPA reviews. So from questions from stakeholders, the courts, and the agencies themselves, they've been asking how to do this. So this is our best guess at the way to do it.
Okay, so let's say a disaffected party to like a permitting document. Could they seek a legal appeal and use the guidance against an agency that did not accept it?
This is new guidance that's not final yet, and I can't speculate on how individuals will use it in the courts in the future.
What do you think about that question, Mr. Marcella?
Well, thank you, Vice Chairman. Your questions go exactly to my point on why I believe the guidance needs to be withdrawn now as CEQ considers it further. At the end of the day, we have a practical reality in two perspectives. One is let's take the Forest Service as an example. Even though it's a draft guidance, no one at the Forest Service is going to ignore it. They're going to give deference to CEQ, and no one at the Forest Service is going to risk not paying attention to the draft CEQ guidance. It is de facto in effect, in my view, across the federal government. And from the court's perspective, let's say the Forest Service says, well, we're going to disagree with CEQ. What's going to happen is someone's going to challenge that Forest Service decision, take it to the court, and the first thing they're going to say in their brief, well, CEQ said the Forest Service should have done it differently, and the court, again, is going to give that significant weight. So that, I think, is the danger and the risk. While, again, I recognize there's a need for guidance as a general proposition, that's the danger and the risk of having a draft guidance out there that is inconsistent with the law.
Thank you, Mr. Martella, and thank you, Ms. Goldfuss. I yield back.